Iconic. The Economy of Certainty. An Introduction to the Typology of Islamic Legal Theory. Aron Zysow, Harvard University, 1984, Cambridge, Massachusetts. Introduction. At the heart of Islamic law, as of all legal orders, there lies the question of legitimacy. From where do the rules that purport to bind Muslims come? What is the source of their validity? Who is entitled to make authoritative pronouncements as to the content of the law? What are the standards for resolving disagreement as to the law? From a very early period, for reasons upon which we are free to speculate, Muslims came to treat the question of legitimacy along explicitly epistemological lines. Certainty and probability were the fundamental categories with which they approached every question of law. This concern with epistemology sets Islamic law apart from other legal systems that treat their problem of legitimacy in institutional terms. For example, Anglo-American law, where the fundamental division is between common law and statute, and Jewish law, which distinguishes between the law of the Torah and the law resting on rabbinic authority. Its constant preoccupation with epistemology makes Islamic law much more self-conscious than either of the two systems. As for the philosophical bent, much more sophisticated. Usul al-fiqh, the subject of this study, is one genre of Islamic legal literature and corresponds roughly to the general part of jurisprudence as practiced by Western writers as Austin and Kelson. It is not directly concerned with the institutions of substantive law, but with the more basic question of how one derives a legal system from the materials of the Islamic revelation. The voluminous literature on usul al-fiqh contains a vast body of observations on language, legal reasoning and argument, and the assessment of historical evidence. When one takes into consideration the entire range of Islamic legal schools, it seems that the activity of the field of usul al-fiqh continued with undiminished vigor for over 1,000 years, from about the beginning of the 9th century well through to the 19th. A great expert, Badr ad-Din Zarkashi, who died 794-1392, already estimated that the number of questions dealt with in usul al-fiqh was closer to 8,000 than to the 800 suggested by another authority, and further reflection, he noted, only generated more. It is clear that a study such as this cannot reasonably deal with more than a small fraction of these many topics. I have therefore chosen to limit my work to those subjects that reflect the role of usul al-fiqh as the science of the sources of law, and my treatment of each subject has been dictated by a single consideration: the creation of a framework within which the history of this discipline can be undertaken. The richness of usul al-fiqh and its obvious dependence on the other disciplines, such as theology and grammar, make it only too easy to despair of finding those intelligible structures that intellectual history requires. There is a real question as to the autonomy of usul al-fiqh. My own view is that there are patterns which emerge from the study of usul al-fiqh, and it is with some of these patterns, the most basic, that this study is concerned. It should really be apparent that this is more a study of usul al-fiqh than it is of any particular Muslim jurist or legal tradition. Without a knowledge of what is typical, one cannot grasp what is original in the works of the individual jurist. Whatever the institutional importance of the legal schools, when it comes to legal theory, the most illuminating groupings often cut across school lines. Nonetheless, in the interests of intelligibility, I have taken Hanafism as a focal point, and within Hanafism, the Central Asian tradition. Among the Central Asians, I have devoted particular attention to Alauddin as-Samarqandi, died 539-1144. My decision to concentrate on this school and this author is largely, but not entirely, arbitrary. I have had several collateral purposes in view. In the first place, I wish to show that Hanafi usul al-fiqh is informed by the same theological concerns as the writings of the famous Shafi'i theologian Ghazali and Fakhruddin al-Razi. Hanafi usul al-fiqh is not, as is sometimes suggested, particularly legal in any but a superficial sense. Secondly, the autonomy of Hanafi usul al-fiqh should make it clear that the history of usul al-fiqh is not a series of footnotes to Shafi'i's Risala, generally regarded as the first work in the field. Excessive concern with origins has led to the unfortunate neglect of the classical theory, and this despite the wealth of information in the classical treatises that could illuminate the early period. I shall be concerned with the origins only insofar as determining the origin of a doctrine enables us to fit it into a legal or theological setting. Finally, Samarkandi's treatise appears to be a chief source for the legal theory of the school of Samarkand, the most famous representatives of which was Abu Mansur al-Maturidi, died 333-944. Samarkandi reports that Maturidi teaching offer a good illustration of how usul al-fiqh can contribute to the most direct fashion to our knowledge of Islamic theology. Hanafism has the further advantage of providing us with an example of an unusually consistent formalist system, and the great dividing line in Islamic theory is between formalists and materialists. For formalists, the practice, ijtihad of the jurist, is of paramount concern. Ordinarily, the results of this practice are only probable, but their validity is ensured by the fact that the framework within which he practices is known with certainty. This framework is provided by the main legal institutions and by usul al-fiqh. Where certainty is attainable, there is no room for disagreement. But where there is only probability, disagreement is to be expected. Even here, however, disagreement is not inevitable. Should the jurists come to agree on a solution to a question of law, the consensus elevates this solution from probability to certainty. The conditions under which probability enters the law and the mechanism of its elevation to certainty differ from system to system. But in each case, there is an achieved balance between certainty and probability. Where the balance is precarious, it tends over time to give way to another, which provides greater satisfaction to those within, and offers less of a target from those without. For the materialist jurists, probability has no place in the formulation of the rules of law. Every rule of law must be certain in order to be valid. There is no balancing of certainty and probability in materialist systems, and the line between legal theory and law is erased. Because no probability is allowed to enter into these systems, there is no need for its elevation to certainty in the shape of consensus. The sources of certainty, however, to which the materialists can look differ significantly. The Shiites recognize an infallible Imam. The Sunni Zahiris do not. Furthermore, the standards for certainty that are invoked can change over time. In the cases of both Shi'ism and Zahirism, we shall see how the importation of Mu'tazili standards of certainty led to a reduction in the body of information regarded as certain. Stay tuned for more on formalists and materialists, and continuation of page 5.